Good afternoon, all. Thank you for joining us. On behalf of M2K Advisors, I'm delighted to welcome you all to this webinar on proposed liberalization of foreign borrowings. If you look at RBA has been revisiting existing regulations to make them more economic friendly, while at the same time protecting India's interest. If you can look back 3 years ago, in 2022, they have significantly revamped the overseas investment regulation. Now, recently on October 3rd, RBI has released the draft ECB regulations with the intent of making the framework more market linked, flexible, and easier to comply with by the stakeholders. As part of this, RBI has sought stakeholders' recommendation on this draft regulations. To discuss on the impact of the proposed liberalizations, we have with us two eminent speakers, Ms. Shweta from M2K Advisors and Mr. Suhas Bendre from Bendre Consulting to discuss the draft guidelines. Before we kickstart, let me introduce the speakers formally. Shweta is a partner at M2K Advisors LLP. She is a qualified chartered accountant and a cleared company secretary, has a decade of experience. She has extensive experience in transaction tax, both locally and globally, with a focus on mergers and acquisitions. She has advised clients on FDA, ODA funding options, compounding of offenses under FEMA, etc. Now, coming to Mr. Suhash Bendre, founder of Bendre Consultancy, has 20 years of experience at an MNC bank, handling foreign exchange transactions and overseeing regulatory compliances under FEMA. He has managed thousands of transactions related to ECB, FDA, ODA, and has obtained more than 400 approvals from RBI for various MNCs. He has played an active role as an interface between RBI and MNCs. He is a sought-after speaker on matters relating to foreign exchange management and has delivered more than 500 presentations across leading forums. So the agenda for the day is to have a thought process on existing framework, how the ECB regulations and the foreign regulations works. As part of it, Shweta will deliberate upon the existing regulations at a high level and some of the key changes that are proposed in the draft regulations. And then followed by Mr. Suhash, he will deep dive into each of the changes and its impact on a critical analysis basis. Few housekeeping announcements. This session would run about close to 40 to 45, 50 minutes. And then we will open up the floor for question and answer from the audience. Request you to post your questions only in the Q&A box. Thank you. Over to you, Shweta.
Thank you, Prasanna. Let me just share my screen. Is my screen visible and am I audible?
Yeah.
Yeah. Okay. So like Prasanna mentioned, first of all, good afternoon, everyone, and thank you for joining. Like Prasanna mentioned before, Mr. Suhas takes his presentation on the detailed amendments that are there with respect to the ECB regulations, I thought it is probably useful to sort of touch upon the current existing ECB framework and also take you through certain guiding principles which are probably required when we go through the ECB framework, and also look at some of the changes that are there at a very high level. And then Mr. Suhas will take it over and talk about the detailed amendments. So let's start with the basics, which is, what is external commercial borrowings? Because right now in the audience, we have a mix of clients, we have a mix of consultants, and we have a mix of bankers. So we wanted to sort of touch upon the basics as well in the session. So what is external commercial borrowings? Simply put, external commercial borrowings is borrowings by a person resident in India from a person resident outside India. So if an Indian company borrows funds from a non-resident, that would get classified under the external commercial borrowings or the ECB framework. And it's also important for us to recall, before we get into the changes, it is also important for us to recall certain guiding principles which are important for understanding the FEMA regulations. And the first one is the distinction between current and capital account transactions. Current account transactions are, let's say, for example, import or export transactions are freely permissible unless they are specifically prohibited. Whereas capital account transactions are generally prohibited unless they are specifically permitted. So ECB, because it alters the cross-border assets and liabilities, ECB would fall under the definition of a capital account transaction. And therefore, when we read the ECB framework, as long as the framework prescribes certain things as permitted, then those transactions are permitted. But anything which is not explicitly mentioned, or if something is mentioned as not permissible, then those transactions are not permissible under the ECB framework. Now, last month, many of us would have seen, newspaper clippings wherein there were, news articles on the Enforcement Directorate sort of finding out many transactions which were colored as export advances, but were actually external commercial borrowings in reality. So, where there were many entities based out of Kolkata and Delhi, what they had done is they had received money from overseas bank, but to the banker, they had sort of disclosed it as export advances, which is generally treated as a current account transaction. But in reality, if you see within 18 months, they had repaid these advances, say stating quality issues or invoicing issues and all of it, and they had repaid. And then the Enforcement Directorate looked into the transactions and realized these are not current account transactions, but rather capital account transactions. So this is where it is important for us to understand the distinction between the two. And when we assume, when we read the regulations, we should not assume that something is permitted unless it is explicitly stated. Next is an understanding of who is the regulator with respect to external commercial borrowings. So if we read the FEMA Act, with respect to debt instruments and borrowings, the power to regulate them is with the Reserve Bank of India in consultation with the central government. Whereas with respect to equity related transactions, the power to regulate them is with the central government with consultation of the RBI. So ECB framework is governed by the RBI in consultation with the central government. The other important thing for us to note is the entry routes. There are two entry routes, which is automatic, and one is automatic and the other is approval. So automatic route means something that, like I mentioned, is explicitly permitted under the ECB framework. Then one would have to sort of make an application to the AD banker, and that is sufficient for them to receive ECB. Whereas something that is not codified in the ECB framework or something that is explicitly mentioned as not permissible would require prior permission of the RBI. And we cannot assume that something is permitted just because it is silent or there is some ambiguity. With respect to the FEMA Act, it is better for us to take a cautionary approach and only go with transactions that are explicitly permitted under the ECB framework. Now, moving on to the different regulations or the entire literature around the ECB framework, starting with when FEMA Act was liberalized, and then the foreign policy was liberalized and FEMA Act was introduced. There were ECB regulations of 2000, which is the FEMA borrowing or lending in foreign exchange and borrowing or lending in Indian rupees regulations of 2000. After that, 18 years later, this was superseded by the Foreign Exchange Management Borrowing and Lending Regulations of 2018. There was a major overhaul after this in 2019 as well, where there were different, when the regulations of 2018 were introduced, there were different tracks through which you could raise ECB. I think all of them were combined in the 2019 amendment to the 2018 regulations. And after that, we only see amendments right now, like key amendments. There were, of course, clarifications that were introduced now and then, but key amendments have been introduced 6-7 years later to the 2018 regulations. Like Prasanna mentioned, these were introduced by the RBI, again, because the power to regulate the framework with respect to external commercial borrowings is with RBI. The draft changes were introduced by the RBI for public comments, which were to be submitted by 24th of October. Now, we also have the master direction, which is sort of the Bible for us to, read the ECB framework, which has all of the changes to the regulation combined and introduced. And there are also FAQs to external commercial borrowings, which sort of give clarity on certain positions which are not clear. So this is the entire literature that surrounds the ECB regulations. The next is, understanding the distinction between ECB or NDI and debt instruments, because there are different ways in which a person resident in India can raise money from non-residents. So the first, if you look at ECB framework governs, loans, non-convertible instruments, let's say, for example, redeemable preference shares, and optionally convertible instruments such as OCRPS or OCDs, FCCBs, etc. External commercial borrowings do not include trade credits, debt instruments, and export advances, and few other things have been excluded from the definition of external commercial borrowings. Non-debt instruments, on the other hand, include equity shares, compulsorily convertible instruments such as CCDs, CCPS, and convertible notes issued by certain entities like startups. Debt instrument regulations, on the other hand, they cover specific scenarios of investments. Let's say, for example, investment by foreign portfolio investors or investment by non-resident Indians in certain securities which are listed, such as government securities, corporate bonds, commercial papers, etc. So these are the different regulations that sort of govern the framework for raising funds from abroad. And like I mentioned, the power to regulate for non-debt instrument regulations is with the central government, but with respect to ECB and debt instruments, it is with RBI. So now let us look at some important concepts and what the current regulations prescribe and what the proposed regulations prescribe. The first concept which is important to understand the ECB regulation is who is an eligible borrower, meaning who has the right to receive funds from a non-resident. Under the current framework, the eligible borrower is defined as all entities eligible to receive foreign direct investment. So now when we look at the foreign direct investment framework, if we read the definition of foreign direct investment, it says investment in an unlisted company. So earlier, the understanding was that only companies were allowed to receive FDI, and therefore only companies could receive ECB. And this was also explicitly clarified by the RBI in the FAQs, where they said entities such as LLPs cannot receive ECB. Now, what they have done is they have proposed to amend the definition of the eligible borrower by stating that it is any person resident in India, incorporated, established, or registered under a central or state act. So the definition has been widened to a large extent to include even entities like LLPs, to include, let's say, registered partnership firms or registered trusts, as the case may be. They have also specifically provided that it has to also be in accordance with such act, right? There should not be any restriction under the act. For example, under Companies Act and the deposit regulations, if we see, deposit regulations say that, any amount that is in accordance with the FEMA framework will not be treated as a deposit. So similarly, there should not be any restriction under the said act for the entity to receive any ECB. So this has, largely increased the scope of people who can receive ECB. Next is the definition of a recognized lender. Earlier, the definition sort of said that it had to be a resident of, the lender had to be a resident of FATF, IOSCO countries. And it also said that individuals were permitted to lend money only if they were foreign equity holders. And foreign equity holders were defined as people who held 25% directly in the Indian entity or 51% indirectly in the Indian entity. So individuals in general were not permitted to lend money to an Indian entity unless they were foreign equity holders. Now they've again widened the scope to a large extent to state that a recognized lender is any person resident outside India. So it does not matter. Individuals can lend money even if they don't have any equity holding in the Indian entity. And there seems to be no restriction on what type of countries the ECB can come from as well. The another important, terminology with respect to external commercial borrowings is the minimum average maturity period. This talks about the duration for which the ECB has to be subsisting. In the sense, it has to be there for a minimum period of so and so years. And the definition of minimum average maturity period varied depending on the type of purpose for which the borrowing was made, and also from depending on the entity from whom the borrowing was received. So this had different brackets. There were, there was a minimum average maturity period prescribed for 1 year, 3 years, 5 years, 7 years, 10 years, depending on the purpose. Now there is a standardization of the definition of MAMP to state that MAMP is 3 years across all types of borrowings, regardless of the purpose, regardless of the person from whom the borrowing has been received. Manufacturing entities continue, the MAMP continues to be between 1 and 3 years, up to $50 million. Interestingly, they have also mentioned that MAMP criteria will not be applicable to certain specific transactions. For instance, they have stated that MAMP will not be applicable, let's say, if there is a conversion of the ECB into non-debt instruments, or let's say if there is a waiver from the lender, there is no condition or procedure that has been prescribed for this, but somehow they've included that also as one of the conditions for waiver of this MAMP condition. Then they have also sort of indicated that if you have raised foreign funding through non-debt instrument regulation, rules and regulations, using those proceeds, you can repay the ECB and MAMP condition will not be applicable. So let's say you have a non-debt instrument that has been issued to a non-resident and you've received money. Using those proceeds, you can repay the ECB and MAMP condition will not be applicable. So these are some changes that they have introduced with respect to MAMP. Next is all-in cost, which is your interest rate. Earlier, it was the maximum interest that could be charged was benchmark rate plus 450 to 550 basis point spread. Now they have changed it and they have linked it to market rates, subject to the satisfaction and discretion of the AD banker. Of course, there's nothing else that has been prescribed except this. And they have also sort of indicated that if the transaction is between group entities, then arm's length condition and transfer pricing conditions will also have to be satisfied. Now coming to end use talks about, the permissibility of what you use the ECB for. And under the current framework, there are certain businesses, certain sectors for which you can't use the ECB proceeds. And there are some rationalizations, some amendments that have been introduced to this, and they have sort of linked all of it to the FDI framework. So something that is permitted for FDI may also be permitted for ECB. Interestingly, if we look at the draft regulations to the amendments for branch as well, because recently they have also, introduced draft regulations for setting up of branches in India. So over there also, they have linked the permissibility now to FDI. So across all of these regulations, what is permitted for FDI is also permitted for, let's say, ECB or setting up of branches in India. So now let's look at some of the changes. Let's say, for example, chit fund or Nidhi company, the same continues, that there is a restriction for usage of ECB funds in these businesses. With respect to agriculture or plantation activities, now they have introduced the wordings to state that if it is an activity or sector that is permitted under FDI, and some of the things are permitted under FDI, and there is no blanket restriction, then that would also be permissible under ECB. With respect to real estate, again, they have linked it to FDI. Earlier, if you look at the current framework, real estate activities included buying and selling of land and all of it, but they gave an exception. And the exception was only for large projects. Let's say, for example, development of industrial parks, integrated townships, SEZs. Only development of large projects were covered under the exclusion to real estate activities. Now, what they have done is they have again linked it to the FDI regulations. So this again widens the ambit, because under FDI regulations, let's say, for example, construction of residential or commercial premises is also a permitted end use for FDI, whereas it was not explicitly covered under the ECB framework. So now that becomes allowed under the proposed regulations. Similarly, if you look at the ECB regulations, current ECB regulations, they state that even leasing is an restricted end use. But if we look at the FDI regulations, FDI sort of states that lease income will not be treated as a real estate activity. So now there is a question on whether buying and leasing of land will also be permitted under the FDI ECB framework. Similarly, if you look at integrated townships, like I said, under current framework, large projects were only getting covered under the exclusion clause of ECB. Integrated township definition was different for ECB and FDI. For example, the minimum acres that were required for development under the ECB framework was 100 acres, whereas for FDI it was very, very less. It was somewhere around 25 acres. So now if they link this to FDI regulations, then I think it opens up a lot of permitted end uses for real estate sector. The next is with respect to trading and transferable development rights. I think the same restriction continues again. The next is with respect to working capital or general corporate purposes. Under the current framework, one could receive ECB for working capital or general corporate purposes subject to MAMP conditions. So if the ECB is raised from a foreign equity holder, the MAMP was 5 years. But if it was from an unrelated party or someone who is not a foreign equity holder, then the MAMP was for 10 years. So many people could not raise ECB for for a longer duration of 10 years. So this sort of felt like a restricted sector, but now there is no corresponding restriction. So one is freely permissible to avail ECB for working capital or general corporate purposes. Just a second. Yeah. Next is with respect to investment in capital market and equity instrument overseas. So this is permitted under the current framework. Under the proposed framework, they have again given on an exclusion for investment in the overseas entities, which was also there in the current regulations. Though it was not explicitly stated in the regulations, it was clarified by the RBI in the FAQs in the old regulations that investment in overseas companies did not fall under the restriction or prohibited end use. So now that has also continued. And they have also given an exception for mergers, amalgamations, arrangements, or acquisitions in accordance with Companies Act, SEBI, and IBC. And when we look at repayment of rupee loans, there is no corresponding restriction again under the proposed regulations. And when with respect to on lending, earlier the restriction sort of mentioned that if you receive ECB for on lending for any of the above activities, let's say, for example, any of the prohibited end use like chit fund or real estate or anything, then it was not permitted. Now, the regulations sort of seem to indicate on lending in general instead of saying on lending for the above activities. And so the question is on lending itself not permitted under the proposed framework? And they have sort of given exception to two classes. One is if, let's say, an entity is having lending business which is regulated, let's say, for example, NBFCs and those kind of companies, then this restriction does not apply. The second is for companies, body corporates lending to group entities. So if, let's say, a company or a body corporate receives ECB and lends that ECB to group entities, then that is permitted under the proposed framework. Now, here it is interesting to note that this exception is given only for companies and body corporates. Though, if we look at the eligible borrower definition, all types of entities which are registered, established, incorporated are covered. This exception of lending to group entities is only given to companies and body corporates. So let's say, for example, a partnership firm receives ECB and wants to lend to group entities. That may not be permitted as an exception in the proposed regulations. And this on lending exception is subject to the condition that it is for permitted end use and it is to a person who is an eligible borrower under the ECB framework. So, of course, there are other changes which Mr. Suhas will touch upon, but the impact of the proposed changes is very welcoming because it gives a wider access to funding through changes in the eligible borrower definition. There is a broader lender base because now person resident outside India will be treated as a recognized lender, and there is no restriction on individuals to lend money to Indian companies. There is a standardization of minimum average maturity period and a lower minimum average maturity period because now it is only 3 years, which results in faster repayment of debt by the Indian companies. There's also simplified end use restrictions because all of it is now linked to FDI, and we don't have to read the FDI and ECB regulations separately when we look at end use. And they've also removed the restriction on borrowing for working capital and general corporate purposes by not having any specific tie-up to the MAMP condition. There's also ease of doing business through simplified reporting, which Mr. Suhas will touch upon. And even the interest rate is linked to market rates. So all of these, changes are towards more liberalization of the ECB framework, which I think is a very positive move by the RBI. Over to you, sir.
You can see my screen?
Yes, sir.
Yes,
Yeah.
sir.
So most of our aspects are touched upon already by Shweta, but I'll touch upon other aspects here. The presentation flows into 8 or 10 slides. I'll take a brief part of each and every one. Now, it is first of all, point to be noted, it is an amendment of notification 3R. It is not substitution. So it is not a repealment of earlier 3R. It is only amendment of FEMA notification 3R. So whatever is not amended, that continues to apply as per 3R. Keep that point in mind. From a regulatory point of view, bankers, consultants, it is not a substitution of 3R. It is an amendment proposed to be introduced. So it is an amendment to the whatever stated there. So for example, regulation 2 is amended, entire definition clause is amended, that is amended. Schedule of ECB is amended, that is amended. What is regulation 6 of FEMA 3R? That is not amended, so it continues to be the way it is. There is no change in that. Regulation 2 entirely definition is completely replaced. Negative list removed from ECB schedule. It is now part of regulation 3A. So the earlier 3A was restriction was there under FEMA 3R plus ECB schedule and negative list. Both are married together now, and there is one common list of end restriction. Earlier there was a separation. Earlier there was a separate restricted list of in 3R also, and there was a separate negative list in the ECB also. Now it is combined together as a 3A, regulation 3A, that is what proposed here. Schedule 1 is entirely changed, ECB schedule. New concept of entity-based ceiling is introduced. So earlier ECB regulation, if you look at, it had a cap of $750 million per financial year for a borrower. Now this cap, it goes away as proposed. And there is a new ceiling proposed to introduce, which is linked to the net worth of the borrower. That's a new change introduced here. Another concept introduced is a lending from NRO account is introduced in the ECB, which was not there erstwhile. And NRI can lend from NRO account ECB as a non-repatriable ECB, which was not there earlier. So it's a new concept. It's a new part. It's good for NRI lending from domestic resources as an ECB. That can be done. That is also proposed to be done here. So these are the broad changes. Again, I repeat again here. It is amendment, not substitution. Definition is completely changed. Some are retained, some are added. Negative list is combined with the FEMA 3R. Schedule 1 is completely replaced. New concept of ECB linked to the net worth of the entity is introduced, proposed to be introduced in terms of ceiling. So every company will have a separate ceiling. Banker have increased job to calculate this ceiling or take some certification. New concept of lending from another account is introduced. It is derived. It is not explicitly mentioned lending from another account, but it derived from one the regulation. I will touch upon that part. What is liberalized? eligible borrower category is widened. LLP registered entity is proposed to be included. Now, I like to bring your attention to one of the erstwhile regulation. The ECB regulation has taken a complete 360-degree turn. I would say ECB regulation has taken a complete 360-degree turn. What started in September 2000, that is kind of introduced again. So I will share my screen separate on a circular. So if you can look at the I hope you can look at the circular. Shweta, can you see the circular?
Yes, sir. It's
Yes,
visible.
sir.
So it is a circular of September 5, 2000. If you look at the para 3, which is highlighted here, who can borrow ECB? Any legal entity registered under Companies Act, Societies Act, Cooperative Society Act, including proprietorship, partnership, will henceforth be eligible to borrow. So in year 2000, even proprietorship was allowed to borrow, a cooperative society was allowed to borrow, a society registration, even trust were kind of allowed to borrow. Any entity could borrow, partnership were allowed to borrow. Now, average maturity not less than 3 years. So here again, in 2000, the maximum maturity was 3 years, which is reintroduced again. ECB up to $50 million. That was the condition at that point of time. Here, only condition which was there at that point of time was loan to be taken through reputed merchant banker. The involvement of merchant banker was there in terms of arranging the loan. Another thing interesting, if you look at it here, that time reporting was required to be done on a quarterly basis. There was a quarterly returns. There were no monthly returns. There were quarterly returns in the prescribed format. There were. So what I'm trying to say here, when the FEMA was introduced in 2000, the first circular which came on the ECB had a similar condition like what is proposed today, that ECB borrower category is any registered entity. It can be a society, it can be partnership, it can be LLP, it can be company, any entity can borrow. Recognized lender, it can be any person resident outside India. ECB equity ratio done away with. Various lender categories linked to MAMP, that is done away with. Subcategory lenders removed. It is only person resident outside India. Earlier, conversion of ECB was allowed from FCY to INR. Now, INR to FCY ECB conversion also allowed. So that's a welcome liberalization. That's the minimum average maturity is simplified. Maximum MAMP. So I mean, maximum, you don't know what maximum. Minimum average maturity, uppermost side is a 3 years now. Real estate definition aligned with the FDI. All-in cost ceiling is removed and it is linked to market conditions. Selective prepayment of ECB allowed before maturity, what is called as a waiver of MAMP. I like to show you some circular here again here. It is a circular of 2002. Can you see this circular of 2002, Shweta?
Yes, sir.
Yes, sir.
So this circular of 2002 allowed a prepayment of ECB about 23 years back, where it said that 100% ECB can be prepaid if it is from EFC balances. Condition B, where the prepayment of ECB is made out of balance held in EFC account of the borrower, prepayment of ECB falling under A and B above without any limit. 10% of the ECB was allowed in the last year for category C and D. So prepayment condition was there right from beginning, right from the last 23 years it was not there. Right. 23 years back, it was 100% prepayment allowed from EFC balances and from FDI proceed. Now, current regulation, if you look at it, it allows some exception like FDI. I will touch upon them once we reach that slide. But some waivers are given right now. ECB to return frequency linked to transaction undertaken. Working capital general capital negative list removed. Conversion of ECB into NDI rule is allowed. Conversion of ECB into. That means conversion of ECB into NDI rule, that means equity shares and LLP capital, that can be allowed. Here, cash is there. If you look at NDI rule does not have corresponding provision for LLP capital. NDI rule has provision for conversion of ECB into equity, but it does not have provision for conversion of ECB into LLP capital. That means in case the RBI introduces this proposed 3R, they need to amend the NDI rule also as from government side to introduce conversion of ECB into LLP capital. Otherwise, this change will not be applicable. It will be on paper, but it will not be implementable practically. It will be. So it says that ECB can be converted to NDI, non-debt instrument, not only equity instrument. But I repeat again, unless FDI rules change, impact will not be there on the LLPs and partnership. Impact will not be there. New condition introduced, interest at arm's length. So earlier, there used to be ECBs from parent to subsidiary, where parent may charge 1% interest, parent may charge zero interest, parent may. So that is to an extent done away with. That is, it is interest at arm's length. That means there has to be some interest element in the ECB. Borrowing limit linked to net worth, I already touched upon that. Definition 2 paragraph change, again touched upon. Negative list combined with the FEMA 3R, that also I touched upon, so no need to repeat that part. Eligible borrower, we broadly touched, I mean, Shweta touched, I also touched upon broadly. The Indian companies, LLP, partnership registered, branch office, project office of foreign companies registered with ROC. They can also have an ECB because they are registered with ROC. They are AIF registered with SEBI, can be also eligible for ECB because they are registered with SEBI. So these are the kind of new entrant in the ECB framework, especially partnership, AIF, branch project office, which were erstwhile not kind of eligible for ECB, but now they can look at borrowing ECB as a person resident in India, registered with some company or whatever. The forms of ECB continues to be same. There's no change. It has to be linked to the repayment schedule. That means it can't be overdraft or cash credit. It has to be a term loan type thing, which has to have agreed repayment schedule and agreed repayment interest. Exceptions excluded from the ECB is a trade credit, advance against export, investment as per debt instrument rule, and convertible note. That is excluded. So here, takeaway from this slide is that AIF can look at borrowing provided SEBI allows them, provided SEBI regulation allows them. Again, I am repeating for the sake of clarity for all audience, entire audience. These are proposed draft regulation. These are not regulation yet. These are proposed regulations. So don't read it that henceforth AIF will be allowed unless RBI introduces the regulation. We can't assume and presume. These are draft regulation. These are proposed regulation. Discussion is on the proposed draft regulation. It is. But if implemented the way it is published in the public website for public comment, then in my view, AIF registered with SEBI, being a registered entity, will also be eligible for ECB as long as SEBI norms permit them to do that. Recognized lender, a person resident outside India and a branch outside India or an IFSC of entity whose lending business is regulated by RBI. So Indian banks, Indian NBFC having a branch overseas with the permission of RBI can be a lender. Any person resident outside India can be a lender. Currency of borrowing, any foreign currency, Indian rupee. Both freely convertible, not earlier regulation. If you look at FEMA 3R, ECB regulation earlier, it says ECB to be drawn in freely convertible foreign currency. Now, in proposed regulation, if you look at the word freely convertible is knocked off. It is not there. It only says foreign currency. That means ECB can be probably availed in non-convertible foreign currency also, which is an exotic currency also can be possible. Indian rupee also possible. Indian rupee need not be always to booster account. It can be from disbursed from another account also by lender. So these are change in the currency of borrowing. The minimum average maturity 1 year, 3 year. These we already covered upon, so I will not waste time on that part because 3 years is the maximum. 1 year is for manufacturing entity up to $50 million. Waiver is for conversion of ECB into equity. India rule, India not of instrument. Repayment of ECB using India proceed. Right back of ECB, waiver from lender. Closure, merger, kind of a IBC, that kind of situation also, waiver is there for a man. Other now use concept conversion of ECB into equity. Now it is using conversion to India rule, India instrument. Again, India will need to have suitable amendment, then only it will be practical. Otherwise, it will not be workable. Otherwise, all-in cost. Earlier, there was ceilings were there earlier. The parameter cost includes what, cost excludes what, and benchmark. They continue to be the same what they were earlier. There's no change in that. They continue to be same. ECB process not to be used to pay cost of borrowing. That also continues to be. Only thing it is linked to market conditions now. The all-in cost is linked to the market condition now. Negative list is the same list from 3R what Shweta had touched upon earlier. Cheat fund, nidhi fund, agriculture plantation as permitted under FDI, not permitted under FDI, except not permitted under FDI. Activity sector permitted for FDI. That is exception, real estate exception is there. Purchasing long-term lease, whatever. On lending for NBFC is allowed, regulated body, and for group entity is allowed. So here this merger amalgamation, there is a confusion here slightly. Transacting in listed, unlisted securities except for merger, amalgamation, arrangement, acquisition, accordance to Companies Act, SEBI, IBC, etc. To my opinion, it means if any entity issues OCRPS as a part of merger, which is currently not enabled, which is, in my opinion, this is what the exception reads here. If you are issuing OCRPS against a merger, that means another company is getting merged into you, or amalgamation or acquisition as a slum sale, then in that case, OCRPS can be issued as a ECB. It's not a question of you raising a ECB and then merging. It doesn't make sense. It is a case where you are issuing OCRPS as a part of merger proceeds. That is what looks like enabled here. We'll get more clarity when the circular comes out. On lending is permitted only for not permitted for non-financial entities. Powers to the AD Bank continues to be same. Cancellation of LRA, change of drawdown, change of cost, refinancing ECB, conversion ECB into India, security creation. So that continues to be same. No change in that. ECB proceeds. These are some miscellaneous guidelines which are touched upon. LRN, obtaining LRN before that continues to be same. Parking ECB proceeding offshore bank account. Now they have widened the scope. Earlier it used to be only in bank account. Now it can be parked in certain permissible investments also. That is an additional change. Earlier it was only overseas bank account earlier. Now it can be certain permissible category of investment also allowed. INR expenditure ECB brought to India, same continues to be same. All parameter ECB compliant to both countries same. Borrower can offer security to lender. That continues to same. Mandatory hedging for infrastructure sector has been removed. So no more requirement of mandatory hedging for infrastructure. Conversion of INR ECB into FCY, that is allowed. That already covered that already. ECB to return to file within 30 calendar days for rate of cash flow. This is looks like a simplification, but it is going to increase the work of bankers, because what is going to happen? That means every ECB transaction has a deadline for ECB to return. If one LRN is there, and there is a drawdown on 15th of October, that means that 15th October deadline for ECB2 is 14th November. That LRN has next drawdown in say 10th of December. That means it has the next ECB due date of 9th January. So ECB2 return due date is going to be dynamic, going to be flexible, and is going to link to each and every kind of a remittance done, transaction done here. That they are going to increase the work of banker. Bankers will be required to follow up with the borrower's constituent to kind of file these returns in time. I had given a suggestion to RBI, kind of remove these owners from the corporate. I had given them suggestion that why not, like trade credit, bankers submit monthly data to RBI on a trade credit. Why not a monthly data on ECB we update from the banker rather than having this monthly ECB return, 30 days return. So that suggestion I had given to RBI. Another thing is Form ECB need to be filed as and when there is a change, within 30 days period from the change, 30 days. Here again, I had given a suggestion to RBI saying that if the change in drawdown repayment date is falling within same month, for example, drawdown date advised to the RBI, it's a 28th of October, and instead of it's 8th of October, and instead of 8th of October, company draws the loan on 18th of October in the same month, then RBI may consider not insisting for revised Form ECB as long as the maturity period is maintained, as long as, because anyhow ECB to return will cover it, or ECB reporting will cover it. So I had given a suggestion to them to kind of simplify Form ECB, where instead of insisting within 30 days for every drawdown change, every repayment date change, if it is falling in the same month, not to insist that. If it is falling beyond a month, then to insist that. So that's what suggestion I had given to RBI here. Refinancing ECB continues to be same. Now ECB, if you look at FEMA 3R, FEMA 3R has a kind of a regulation 9, which says that all earlier ECB availed under the extant guidelines, extant framework, continue to be their maturity on the same framework. Now that means what? If a company had taken ECB for working capital with a 10-year maturity in 2024, they can not repay after 3 years. They have to continue it for 10 years because maturity is 10 years. But the same company today can avail working capital ECB with a 3-year maturity. So here RBI need to come out with, while they propose the changes, they need to come out with some flexibility here for the earlier ECB, because if you are allowing new ECB with a 3-year maturity for working capital, earlier ECB to continue for 9 years, 8 years, or 7 years, it looks a little bit awkward and absurd actually. But we have to wait and watch what kind of changes RBI brings in here. But as of right now, because of Regulation 9 in 3R, which is not amended, which is not Regulation 9 in 3R, there is a kind of a zingo where old ECBs will continue to go the way they were, not getting benefit of the new guidelines here. Last point, which I have not mentioned in the slide here, FEMA 3R under Regulation 6 allows NRI or OCI to lend to other than companies like partners. They can lend to partnership, they can lend to whatever. Now, if you look at ECB definition now, ECB definition now says that a person resident in India borrowing from person resident outside India. That means there is a dilemma there. Regulation 6 provision for NRI lending to partnership, will that be considered as ECB or not? Or will that be considered outside ECB? Because that's an additional provision other than ECB guidelines. That is. So there is a kind of a duplication in the provision. One ECB allows NRI to lend to partnership now with the ECB norms followed. NRI can lend to partnership under Regulation 6 also. So there are two regulations for the same transaction. Which one to pick up? Whether Regulation 6 to be picked up or the ECB to be picked up. So there is a dilemma. I had highlighted that to RBI already. That is Regulation 6 and the ECB proposed guidelines. They are clashing, and there is the same provision for two same transaction has two different types of provisions under circular. So that is what I highlighted to RBI. That is what I mean. So I think, Shweta, we can go to Q&A part.
Sure, sir. Just to add, sir, I think two more changes that, when I was reading, I noticed was that under the current framework, if we see, there is an entirely different aspect that is there for startups. So for startups, the entire governance of ECB is separate. They don't have this condition of MAMP, being 1 year, 3 years, 7 years and all of it. It was only 3 years. And then they didn't have any, end use restrictions and all if it was borrowing by a recognized startup. Now, I think because the MAMP has been reduced and the conditions have been relaxed, there is no separate framework that is there for startups as such.
That is correct. That is correct because startup conditions of startups are applied typically to all the ECB models actually.
Correct. And the second interesting thing is when you look at this security that can be given, earlier it was only movable assets and immovable assets. Now they have also included intangible assets. So that also seems to be one more change that is being introduced in the new ECB framework.
Yeah. I think we can open forum for people who ask questions.
Yes, sir. So when I was reading also, sir, when, I had certain questions on the ECB framework. For instance, let's say you touched upon, conversion of equity to, conversion of ECB to NDI. Now, the question is, this is conversion of ECB into NDI. Now, what about interest? Can interest also be converted into equity shares or NDI, or is there any restriction under the ECB regulations?
See, as per my knowledge, NDI rule allows conversion of any legitimate dues payable under Schedule 1, Para 1, Subpara E. It allowed any legitimate dues payable for which remittance is allowed, and an Indian company being a 100% automatic route that can be converted into kind of equity shares. It doesn't use the word equity instrument. So therefore, even today, ECB interest can be only converted to equity shares, not to LLP capital, not to partnership capital, not to CCD or CCP. It can only be converted to equity shares only. Because NDI rules have a restriction over there.
Understood. The second, sir, is you were talking about the transition provisions in relation to MAMP, right? That there should not be a stricter approach that is given because now the proposed framework sort of gives us lower MAMP conditions. Similarly, under the current framework, some for some end uses or from individuals, let's say, you can only get ECB from foreign equity holders. Now that there is no condition of foreign equity holding, be it for receipt from individuals or for MAMP, can, under the new regulations, can someone transfer the foreign equity holding, or should the foreign equity holding subsist throughout the period of the ECB?
We need to wait and watch what kind of an amendment to Regulation 9 is done by RBI. Because as I said earlier, this is not a replacement of 3R. It is an amendment to 3R. So whatever sections or regulations are not touched upon in the amendment, they continue to be the way they are. So Regulation 9 is not touched upon in the amendment. Regulation 9 in FEMA 3R talks about the earlier framework continues to the maturity. That means the ECB is taken under the January 19 circular with a 10-year for working capital, 7-year for repayment of loan or whatever, end use restriction, those continues for those ECBs. So RBI, it's a feedback to RBI. If they want to bring parity in terms of it, then it's better to have kind of some flexibility given to old ECB. But again, here again, important point is that RBI draws a balance of payment for the country depending on the future payment dates. So if they allow all erstwhile ECBs to fall in line with the new ECB guideline, balance of payment calculation may go wrong. So that's why it's unlikely that earlier ECBs may get relaxation.
Understood, sir. Sir, one other question is, because we touched upon recognized lenders, whether IFSC entities would also fall under the definition of a recognized lender, because what is a person resident outside India? And somewhere the, FEMA IFSC regulations sort of say IFSCs are also treated as persons resident outside India. So the question is whether borrowing from IFSC is also permitted, both under current framework and the revised.
The entities registered in IFSC will be considered as an eligible lender.
Got it.
Yeah.
Got it, sir. And sir, because you touched upon one of the end use of that mergers, acquisitions, arrangements, and all of it, because earlier the wording sort of was very clear to state that the negative list includes investment in capital markets and investment in equity. Yeah. So now, does the restriction still continue, which is, investment in equity markets of domestic equity market, because investment overseas is anyway permitted, but investment in domestic market, whether it is permitted under the current, proposed regulations?
That continues very much the same way it is. ECB proceeds cannot be used to invest in equity capital of the Indian companies or LLPs. ECB proceeds cannot be used for investing in capital market. What exception is done here is for merger, amalgamation, arrangement, acquisition. So instead of paying a cash for merger to the shareholder of the merging entity, if you want to issue OCRPS kind of a ECB instrument, you have to follow ECB guidelines, you have to take LRN and all that. But as an end use, it may be permitted one to issue OCRPS for merger or amalgamation. So that kind of exception is introduced here. But that doesn't mean that you are investing in equity, because when merged entity cease to exist, their shares get cease to exist, correct? So you're not buying shares of that company. The company is merging here.
So what does the word acquisition in that language mean?
It tends to refer to the slum sale purchase, probably. Instead of buying equity share, you are investing it, taking a purchase on a slum sale. That end use may be getting covered as acquisition over there.
So I think some clarification with respect to that clause may be useful, because right now it is not very clear what it is permitting and what it is not permitting.
Introduces the regulation with master direction, it will be much clearer.
Yes. So I will just probably take up the questions that are there in the chat box, sir. The first question that has been raised is working capital or general corporate purpose, will it be under automatic route? I think yes, now because there is no MMP restriction or anything that is there, I think that would fall under the automatic route.
Prospective.
Yes, provided it is finalized, the regulations are finalized.
Not only finalized, but for prospective ECB, not for old ECB.
Yes, new ECBs, correct.
Yeah.
Next is whether all-in cost is still benchmarked to SOFR rates. That I think you have clarified that.
It is benchmarked to SOFR rate, but the ceiling is not linked there. Ceiling is market-driven, but how to calculate the ceiling? For example, it is market says that market interest rate is SOFR plus 300 basis points. That's the market condition. Then that becomes the benchmark. Benchmark becomes dynamics now. It's no more static benchmark. It will change from market condition to market condition.
Yes, sir. The next question is, any suggestion can be given for making ECB to return to be filed online through AD bankers?
So I had given suggestion to RBI to discontinue ECB to corporate. I had given suggestion to RBI to ask bankers to do a monthly reporting, because anyhow bankers are doing it for trade credit. Today nobody reports trade credit as a corporate. Trade credits are not reported by corporate. Trade credits are reported by bankers to RBI on a monthly basis as an inflow outflow statement as well. So why not replicate that for ECB too? having said that, if RBI does not accept it, then this online in the pipeline is there, but I'm not sure when it will see an end of tunnel. I mean.
Yeah, in fact, even for ODI, sir, because manual filing is a pain actually. If we look at it, FDI is very streamlined, but ODI still, because manual filing is still a challenge.
Yeah.
Some of these things could be made online. The next one is, how about other costs, like in case of prepayment charge, penal interest, if any, for default or breach of covenants?
That provision continues to be same the way it was earlier. So that 2% or selling that permissible cap, that will continue to be there in addition to all the costs.
The next question is, any quantum or limit given for ECB from NRO account or no limits?
So it's a limit per borrower, correct? As I said earlier, it is no limit for a standard limit. Nothing like a $750 million or $1 million or $5 million, nothing of that sort. The limit will depend on the net worth of the borrower. If you look at the regulation, actually, I'll share the regulation also. So if you look at the regulation, the regulation talks about ceiling linked to the net worth of the party. If you look at FEMA Amendment 3R, if you look at now, limit. An eligible borrower may raise ECB up to the higher of outstanding ECB or $1 million or outstanding borrowing up to 300% of net worth of last value balance sheet. Higher of, so 1 billion is the limit maximum, but 300% net worth is also conditioned there. So higher of 1 billion or 300%, which is higher. So from big large MNCs, large companies who have a good amount of net worth, a 1 billion condition will not stick there. Others will have 1 billion as a cap. In outside for cumulative outstanding, not per year. It's not per year. It is cumulative outstanding ECB. So, for example, some company are already have a receipt for $1 billion. For them, automatic growth is zero unless they are net worth. You got my point, Shweta?
Yeah, I think the old regulation said 750 million per year, but now
they are saying 1 billion, including all outstanding ECB. So if some company already has ECB exposure of $1 billion or say $800 million, that means they have a window of $200 million only now.
Yeah.
Not $1 billion. Or unless they have a net worth which is exceeding $1 billion. So that is where the condition has been put in.
The next question is, can a non-resident individual provide ECB to an Indian company? I think we've clarified, because the definition of recognized lender is expanded to say any person resident outside India. So even a non-resident individual can provide ECB to Indian company.
I'll show you some part of the circular which I was referring to here. If you look at para 15.2, can you read? This is the para 15.2.
Yes, sir.
Repayment of, in case of ECB availed from NRO account of the lender shall be credited to NRO account. So that is where I am inferring that NRO ECB is allowed. You got my point? It says the repayment of ECB availed from NRO account from the lender shall be credited to NRO account. So that means ECB can be availed from NRO account. If the question is how much ECB can be lent from NRO account, ECB, it is based on the limit available, maximum up to $1 billion total outstanding, or 300% of the network, which is higher. That much can be lent from NRO account. Next one, Shweta.
Yes, sir. Next one says, can the offer letter from lender IBU be considered as an agreement for applying LRN and subsequently enter into agreement with the borrower? I am not clear on what.
Question of framework of ECB, so we will not answer that question. It depends on the AD banker and policies, internal policies. Okay. And what is the meaning of agreement word as interpreted by AD banker? So we will not answer this question on this call.
Yes, sir. The other question is, can ECB be used for acquisition for capital assets under proposed framework? As per existing framework, it is permitted only for working capital.
No, ECB negative list is there. Why I don't know. I can understand why somebody is saying that ECB can't be used for capital asset. The restricted list does not include capital asset. The restriction doesn't say capital asset anywhere. This is the prohibited end use for borrowed fund. Nowhere it says capital asset is restricted. Nowhere. I'm not really sure why this question is coming up. I mean, it nowhere says that capital asset cannot be purchased. Right? And if you look at schedule of ECB, if you look at the end use restriction is not there in schedule at all.
Yes, sir.
It is only under para 3A. It is only under.
Due to this proposed change in interest payment on ECB withholding tax rate changes, if any, there's no change in withholding tax rate. I'm not clear what that question is. So I'm not getting into that. I think other questions have been answered, sir.
So we can open the forum for if somebody wants to ask on the call. If any audience want to ask, or if any question is not clear, answered, any doubt, we can unmute the person. You can.
Yeah, you can raise your hand. Otherwise, unmuting is not possible. You can raise your hand and we can probably unmute you.
Mr. Balaji is there. You can unmute Mr. Balaji.
Tejashree, can you unmute Balaji, please?
Yeah, good evening all.
Yeah, good evening,
Is it
Balaji.
audible?
Yeah, you
Is
are
it audible, sir?
Yeah, very
so
audible.
the TDS rate, sir, it's the 5% or it is 20%.
This is a
So
tax
loan
matter.
borrowed.
Balaji, sir, is a tax matter. I will not be able to address the tax matter.
So,
Okay, sir.
To answer your question, Balaji, that 5% rate has a sunset clause. Now that is no more available for any new ECB. So obviously it will fall under, if it's a foreign currency, then you go to 115A where it is 20%. Otherwise, you can look at the respective tax treaties subject to they entitle for treaty entitlement.
Okay, sir. Okay, thank you. Thank you.
Nilesh, you can unmute Nilesh.
Tejashree, can you unmute Nilesh?
Yeah, good evening, all. Yeah, regarding that other cost, you have answered, but in the proposed draft, it is mentioned as the prepayment charge or penal interest, if any, for the default or breach of conveyance shall be in line with the prevailing market conditions. They are not given or they are not mentioned any ceiling. That is for in earlier, it was a 2% penal interest charge. Okay, but in the proposed, they have not mentioned anything regarding this.
Yeah, but past experience of the bankers actually from my side is that typically they will refer to what guidance RBI has described. Otherwise, it is difficult to refer to market condition for a penalty. I mean, penalty. And if 5 bankers on the street adopt a policy to define 2% as a threshold, most of the bankers will adopt 2% as a threshold. You are right, Nilesh, right to regulation is silent on it. It's not prescribed, linked to market. But market is not, may have an interest rate as a kind of a Bloomberg or whatever you get the interest rate. But whether on the Bloomberg or whatever you get a penalty rate is a doubt. I doubt really.
Okay, but I feel we should get the clarification from the RBI. It will help all of us rather, because it will otherwise be a conflict when we are going to be handle this kind of a transaction, ECB transactions.
Very true, very true, very true.
Okay, thank you, sir.
Harsha had raised the hand, I think.
No, Harsha is from our team.
Our side. Okay. Anybody else have any questions?
I think nothing else, sir.
So possibly if you may permit me to ask one question.
Sure.
So with regard to ECB from a related party, it mentions that it shall be at arm's length basis.
Yeah.
So whether this arm's length basis should be looked at from the viewpoint of the ability or to what extent the loan can be borrowed by the company, or it is confined only to the interest rates.
The arm's length is, let's look at regulation rather than kind of making wild guess. It's an arm's length principle. ECB from a related party group entity, otherwise connected lender, shall be carried at arm's length basis. That means it's broad. It's not only for amount, but it's also for interest, amount, interest, everything. But primarily it will be interest to primarily it will be.
Okay. Okay, sir.
I think we can conclude, sir. No one else seems to
I
raise
repeat
any.
again for the sake of kind of a clarity. The session was on proposed draft regulation. These are not valid today. So don't take away from this regulation that things have changed. Things have not changed. These are draft regulations proposed by RBI. Wait for public comment. Comment may change the circular nature, may change the provisions. So we have to wait and watch when RBI publishes the regulation. This was just a kind of an idea being given. What is kind of a changes like the key changes? If I recalculate key changes here again for audience, NRO lending is a big change. Lending from NRO account is a bigger change actually in NRO account. Secondly, arm's length interest is a big change for MNC subsidiaries. Because MNCs were giving an interest-free loan or a lesser interest loan. So if they start giving loan for 5%, 8%, what will happen? It will be from pocket A to pocket B within the group only. Government will make money on it. So if a parent company lend to an Indian subsidiary and interest rate is charged at 300%, 300 basis point, 3%, which was earlier supposed to be 1%. So 2% extra interest will go from India to parent, but government will have a cut on the taxation on it. That arm's length principle changes the borrowing cost dynamics. It changes. Third thing is the limit, ceiling limit. $1 billion includes cumulative ECB. So a big corporate like MNC, big MNC corporate likes of L&Ts and likes L&Ts and they would have crossed their $1 billion probably much long back. Now they have a window of 300% net worth. That window they have. So if the net worth is more than $1 billion, they can have 300% of net worth. So for example, some company net worth is $500 million. For them, the limit becomes $1.5 billion, not $1 billion for them. So that limit is the dynamic. So it's one of the biggest change. Welcome change is working capital and general corporate purpose. That's a welcome change. That really. So I hope it was useful for the audience in terms of the synopsis of what changes happen. I think you can wind up now.
Yeah. Thank you, Shweta and Mr. Suhas, for taking us through the crux of the regulations that are proposed to be implemented. If it goes well, it brings a lot of certainty from an MNC standpoint, and also reduces the compliance and the relaxation of the utilization requirements of the ECB. And it also gives a glimpse of what awaits the stakeholders once the proposed amendments are implemented. Thank you all for joining us. Thank you, Shweta and Mr. Suhas, once again. Thank you.
Thank you. Thank you, sir. Thank you.